I really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
Filing my cases shouldn't be that difficult. There's got to be an easier way.
Nothing frustrates me more than having to wait for my attorney to call me back. I need them now.
What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
Good afternoon and welcome back to the Zona Law podcast. I am Mark Zinman.
Scott Balua from Zona Law. It's great to be here, and we're back here today to talk about some new changes in the law that community managers have been asking about.
Yeah, we're actually, amazingly enough, not going to talk about a moratorium or other delays or other restrictions on managers' rights. Well, maybe it's a restriction. I'm not sure. Today, we are talking about the election. Today is November 17th. The election has mostly subsided, if you will, and one of the things that happened is the voters in Arizona passed Prop 207. Which is what?
Well, Prop 207 deals with the recreational use of marijuana by adults. The law essentially goes into effect November 30th, and once the results are certified, and then anyone that's 21 years or older will be able to have recreational use of limited amounts of marijuana.
That's I think it's 1 ounce, right? You can carry, possess, smoke, use 1 ounce of marijuana.
Correct. I believe that's what the cutoff is. And, this is a change, and we just want to make sure that the community managers are aware of how this affects, processing evictions going forward or handling the questions that ultimately a lot of community managers are going to receive from other residents and from people that previously had medical marijuana cards or other individuals who may wish to use on property.
Yeah, and so I made a joke earlier about not restricting. This podcast isn't going to be about restricting landlords' rights, but the question is property rights do come in. And so the question, I started getting calls and emails on it the night of the election, is if the recreational is allowed throughout the state of Arizona, can a landlord prohibit use of recreational marijuana on their property?
And yeah, that's the same question I've been receiving from a lot of community managers as well. And so when we think about property rights, when we think about the relationship between a landlord and tenant, we're thinking about what does the contract say? A lot of people talk about, the First Amendment right, the rights to free speech. We talk about individual landlord rights in that context as well. Well, if you're a landlord and you own a property, then you can make certain restrictions as long as it's not prohibited by law about how you want the property to be managed.
So unequivocally, if you own a property, you have a right to put in your lease, we do not want marijuana on our property, period. Whether recreational, whether medicinal, simply we will not allow it on property, right? Why would a landlord do that?
Well, the number one reason is because of the effect that it would potentially have on the rest of the community. The analogy I always use is, could a landlord prohibit the use of regular smoking, cigarette smoking, tobacco use?
They do it already.
Yes, they already do. Well, if you have a lot of residents in the community, they're all living in tight quarters together, inevitably what's going to happen is that cigarette smoke, that marijuana smoke, it's going to have an effect on the neighbors. It's also going to have an effect on the building itself.
Yeah, I've got 2 young kids. If I'm in an apartment community, I don't care if marijuana is recreationally permitted. I don't want my neighbor smoking marijuana and then coming into my unit and disturbing my kids. Right. Also, if I'm a landlord, I don't want the damage simply that smoke causes. Smoke unequivocally causes damage to units. It destroys your paint. It destroys your carpet. It is disgusting to clean out and oxidize after it happens. It costs landlords money.
Yeah, there's a lot of remediation costs that go into, you have to go and replace the carpet potentially. You're going to have to do treatments, special treatments to the walls in order to be able to remove that smell. And a lot of the unit will essentially become, unusable because you don't want to turn it over to a new resident, and then they come in and they are like, well, I can obviously smell that somebody was smoking in here previously.
Yeah, so we know first off then, absolutely if landlords want to, they can prohibit in their lease the use of recreational marijuana. How does that play out in court then?
Well, so I guess to start that question is, how do community managers usually find out about this issue? Well, usually it's a neighbor that says, hey, I can smell cigarette smoke, I can smell marijuana smoke, and, I have kids and I'm worried for their safety. So just like with anything else in court, well, what do you have to do to show and prove that that condition exists? It's very difficult with marijuana and with cigarette smoke. It's not easy to record it. It's not easy to do anything. You have to rely on personal knowledge. You have to rely on an individual being able to say, well, I know what cigarette smoke smells like. I know what marijuana smoke smells like. In the past, one of the ways that we used to handle that issue was if you contacted law enforcement and law enforcement came in and they did an investigation and they found out that, look, this person was illegally in possession of marijuana, well, then that makes the case much easier. We can't rely on that anymore, can we?
No, that was the problem. And with recreational, police didn't want to come out either because they're saying, medicinal. The person may have medical marijuana cards, so we're not going to be able to charge them with anything anyways. But a lot of times the police would come out, just identify and say, yeah, it's marijuana, but we can't charge them because they showed us a card. I kind of think police are going to come out less and less on those, and it's really going to come down to the communication with other residents, that other residents are willing to come into court and saying, yeah, it's obnoxious smell. We smell it all the time. It's disturbing our quiet enjoyment. And that's where it goes to the question of whether you think you're going to win on an immediate, for example, for somebody smoking, or if you do a 10-day for the repeated, disturbing quiet enjoyment.
And it was more of a clear-cut answer previously, because you could say that the recreational use of it was not only in violation of federal law, but also a violation of state law as well. And if there was the potential for a criminal prosecution for it, then an immediate is more appropriate. Well, now that landscape has shifted a little bit, and instead of doing an immediate, it might be more advisable to do a non-compliance notice. Give the person the 10-day period of time to be able to cure it. Then if there's any continuing activity with regards to that issue, well, then you can address it.
Yeah, but I think it depends also on the facts of each case, right? Because if it's egregious, if they're growing it in the unit, if they've got 2 pounds of marijuana, that might still be an immediate, because people have to remember it is a violation of federal law still, period, end of sentence. So some cases it may be better to do a 10-day, some cases it may be better an immediate, and it really is a judgment call for the manager as they discuss it with their attorney.
Correct. The facts of every case will call for maybe a slightly different analysis. Another way that this issue also gets brought up is, residents make maintenance requests. Maintenance comes into the unit. They end up seeing paraphernalia. They can smell it in the air. I know that sometimes there's classes that are offered for community managers so that they can learn to detect the smell of marijuana. They can learn to detect, what kind of paraphernalia is used, and then, at least from our perspective, if we have to go into court, if we have an individual that has that specialized training, then it makes it much easier to be able to say, well, no, we can show and prove that this is something that has been going on and that it's a breach of the lease agreement. So what if you don't have a provision in your lease that specifically prohibits the use of marijuana?
Oh, it definitely makes it more of an uphill battle. If you're using the general crime-free, it references federal law. So, again, that would bring in the federal law, Controlled Substance Act, prohibiting any use of marijuana, whether recreational or medicinal. And so I think that's a good fallback. But our general suggestion is landlords should change their crime-free addendum, or just have a marijuana prohibited addendum saying, I understand it's recreationally permitted. I understand it's medicinally permitted. We do not allow this on property, period. And that'll make it clear. So when you get into court, you don't have those kind of, he said, you don't have to argue over the contract. You just prove your case.
Right. And so lawyers like playing the what if game. What if the federal government decides to go ahead and take it off the controlled substance list? Does that change the analysis here?
No, it's a great question. I think people have been tricked by it. In my perspective, no. If it becomes, even if it is legal on a federal level, meaning it wouldn't necessarily fall into the crime-free, you could still have an addendum that says you can't use it because, again, tobacco's allowed. And I even dumb it down from there. Like, TVs are allowed. Okay, you can watch TV on our property. Of course, I'm not going to restrict it. But once it starts blaring and disturbing other people, then it's disturbing the quiet enjoyment. You can be evicted for it. Also, what people don't realize, we have a Second Amendment that protects the right to bear arms. A property owner can say, we don't want guns on our property. That's a property owner's right, as long as they put that in the lease and restricting up front.
And that's another common provision or addendum that I see in community rules and regulations, is they prohibit it, or they make restrictions that, you can only have it in your car and it must be carried in a locked box. I've seen very specific addendums that deal with that issue and can be only carried from the unit and back to the car, can't be displayed on property. And, certainly people are going to try to argue that the Second Amendment is what controls here. But just like any contract that you enter into, you had an opportunity to read that contract. You had an opportunity to say, well, I agree to moving into this community with these stipulations. And then if you breached that contract by not doing what you're supposed to do, the Second Amendment isn't a defense.
Yeah, and that's why I can't stress it enough. And this goes for everything on Zona Law Podcast. This goes for everything that we always advise clients. Make sure your lease reflects how you want your property run, whether it's smoking, whether it's obnoxious noises, whether it's guns. You have the right before you enter into those leases to control what goes on in your property. And that's your chance, not after the fact.
Right. It's very difficult because one of the questions in the lead up to the election was, well, can we prohibit the use of political signs on the property? People wanted to display flags, or they wanted to display signs for their particular candidate. And the first question we always ask is, well, what does your lease say? It doesn't need to say maybe specifically political signs, but it could say something along the lines of, we prohibit the display of banners, signs, or any other type of advertisements on the outside of the unit. And if you have that, well, then yes, you can enforce that, just like with any of these other regulations.
And I think we've seen from this election, definitely it's a good idea to do whatever side of the political aisle you're on. You don't want to be walking through an apartment community, which is like gorgeous landscape, beautiful buildings, and just be covered with signs everywhere. I mean, generally you prohibit signs from being seen outside of the unit, and it just keeps the property looking clean.
And it, just like with the prohibition against marijuana, what is going to help bolster the sense of community? Well, making sure that everybody has a set of rules that encourages everybody to get along, and having political signs up or allowing people to smoke marijuana on property, that's going to definitely negatively affect other people or the property itself. Like, all these things are tied together for the same common goal, and that common goal is to make sure that everybody gets along in the community.
Yeah, so that is the short of it from us, which is you can prohibit marijuana, even though it's recreational. You can prohibit it from being on property. We strongly suggest you address it in your lease and clarify it.
Correct. Yeah, very well said.
All right. So until we see you next time on Zona Law, because I'm assuming things will be changing faster than they always do. Thank you guys so much, and we'll see you next time on Zona Law.